fine. Here.
Okay, so
You gotta mute yourself, somebody's.
Angela.
Man, this is. What is this? I can't. I'm trying to get in. I can't hear. I can't hear them. I'm not Hebrew. Hello?
We're not quite ready to start. Thank you. Jack, are you in a new office?
Yes, yes. Although I'm actually going to move the computer a little bit to a better location. Let me tie the noose around my neck and everything. I've always said that one day they're going to dig up all the men, 400 years from now, and they're going to say, why on earth did they all choke themselves to death with those things around their necks?
And Jack, just so you know, technologically speaking, the way we set this up is City Hall chambers are open, and Brian Shea is there with some of the owners and the respondents on these code hearings. So they'll be appearing on Brian's screen.
Okay, that works. Let me just pull up our agenda real quick. And I'm ready whenever y'all are. Are we all here, or are we still gathering, or what?
I can't speak for the respondents, Mr. Bridges, but I believe everybody from city staff are here. I will not be prosecuting today, just advising city staff on the legalities of their cases.
Okay. Okay. All right. So in that case, I guess we should go ahead and start. Is that right?
Whenever you're ready, Mr. Bridges.
All right. Well, okay. Good afternoon, everybody. My name is Jack Bridges. This is the Marathon Code Compliance hearing docket for September the 17th at 2 o'clock. It is now 2:01 p.m. We're conducting this by Zoom. The first thing we'll be doing is beginning the Pledge of Allegiance. As most of us don't have a flag in our office or our home, unless someone objects, we'll just go ahead and dispense with the Pledge of Allegiance this time. Nothing against the flag. Next time we're in person, we'll say the pledge twice if we need to. Does anybody have any objection to that? Okay, none is heard, so we'll go ahead. Very briefly, there's a few things that I want to advise everybody of. First of all, it's regarding ex parte communications, and ex parte communication is defined as any contact, conversation, communication, writing, correspondence, memorandum, or any other verbal or written communication that takes place outside a public hearing, which this is, between one of the members of the public or a member of the city staff and the special magistrate in a quasi judicial hearing. This site visits and expert opinions are also considered ex parte communications in the event that somebody has contacted me about a quasi judicial matter that's going to be heard at this public meeting. I will let you know at the time that that item is brought up about the ex parte communication and who initiated it and whether it would affect my ability to be fair and reasonable and neutral in this case. And to my knowledge, I've not spoken with anybody about any of these cases. I've not even looked at the evidence that has been presented as of yet, pursuant to my conversations with Mr. Jones and the way that we do it in the city of Layton. Once the evidence is introduced by the city, I'll ask the respondent if they have any legal objection to it, and then and only then will I look at what that evidence is. As far as the way that we conduct the hearings, I just want to let the individuals, the respondents know. Many of you may not have been in code enforcement court before. The way it usually works is you have a right to a trial. As to the city has alleged that you have committed a code violation, you have a right to a trial on that. Now, in some cases, you may agree that there has been a violation. You may say, I just need a little bit of time to remedy it. If that's the case, then you can go ahead and admit to the code violation if you wish to do so. And what I'll do is I'll listen to what the city recommends, what you recommend, and then I will, in most cases, assess a compliance date, which in most cases is, well, in some cases it's 30 days, some cases it's 6 months, but usually they're 30 days to pull a permit to do whatever it is that you need to do. Some things don't need a permit. And as long as you get it done during that 30 days or whatever the compliance date is, there's not going to be any fine whatsoever. The only thing I do have to do, I don't have any choice. I do have to levy an administrative fee. That's part of the city's ordinances, and I don't have any choice about that. If in fact you decide that you contest the allegations against you, you can certainly have your opportunity to be heard, and then I'll make a decision after that. If there's no finding of a violation, then you're free to go. There's no administrative fee. If there is a finding of violation, again, I have to assess the administrative fee. But what we do in most cases is we go ahead and assess a compliance date. And as long as you comply by that time, there's not going to be any other fines. Now, there are certain things that are called irreparable violations, in which case we don't have a compliance date. And there's certain allegations sometimes that we set a very short compliance date. We'll deal with that on a case-by-case basis. With regards to the minutes from the previous meeting, I'll go ahead and approve those at this time. And at this point, I'm going to, what I'll do, since I can't really see everybody in there, I just see something that says, I think you all can all see it too, public podium. And there's a gentleman there with a mask. Hello. What I'll do, okay, here we are. We're looking like the Brady Bunch now. And what I'll do is, as each witness comes forward to testify, I will go ahead and swear them in as a witness. You have a right to cross-examine any witnesses that the city brings against you. That is, you can ask them questions. Third persons have the right to also testify if they wish to do so. However, anybody who refuses to be sworn, I'm not allowed to consider their testimony. All right. And so I guess at this point, we'll go ahead and call up our very first case. This is going to be case number 2017-0169. The respondents are Estelle Williams, care of Maggie Williams, Sarah Battle, Veronica Williams, and Johanna Tucker. This is an unsafe structure case. And do we have anybody here for Ms. Williams or the Tuckers or Ms. Battle?
Miss Williams, you're going to have to unmute yourself.
Can you hear me?
Okay,
Yes,
I can
ma'am.
hear you. I don't see you, but I hear you.
Yeah, I'm on the Hebron. I don't know. That's just my grandson. He's on the
Okay.
Zoom virtual learning. I don't know how that happened, but I was trying to get in correctly.
That's
I'm
no problem.
sorry. How are you
Okay.
today?
I'm fine, thank you. Are you going to be testifying in this case?
Yes, I
Oh.
guess I am on behalf of my sisters.
Oh, okay. Now, it's charged with an unsafe structure. Do you wish to admit the violation or do you wish to contest the violation?
I don't know. I guess it is, but we have done some work to it. Not
Okay.
as far as the building itself, but we have cleaned up the area. We have cut down I guess the bushes and the trees that might have been, inconvenience to that property. We are also we did do some, under my understanding now, I am in Savannah, Georgia. So I'm not down there to actually see, but I do have a sister, Maggie Williams, that is down there, and she is overlooking the property. And she said that they did go over there and clean it up, and they did, I guess, tape up some of the windows for now. So that is just as much as I know now of what's going on. And let me see what else she was saying.
I'll tell you what, I'll go ahead, if it's okay with you, I'll go ahead and accept this as an admission. And then what I'll do is I'll hear from the city, what they have to say, and then I'm going to come back to you and give you a chance to respond. Is that okay?
Okay.
Okay.
Okay, that will be.
Okay, and by the way, Savannah, Georgia is my hometown. So
Really?
yes, it is.
Oh,
I live on Barnard Street.
okay. And Marathon is my hometown. Born and
All
raised,
right.
graduated from Marathon Highs, class of 79.
Okay. All right, who do we have testifying for the city?
Mr. Bridges, we're going to have Angela Yetter testifying on behalf of the city. And just so you know, this is not a first-time hearing. This is a non-compliance hearing based on a previous order that had been entered last year. So I'll go ahead and turn the floor over to Ms. Yetter to explain why we're here today.
Okay, Ms. Yetter, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
you.
Okay, go ahead.
Yes, I am Angela Yetter, the Code Compliance Officer currently assigned to handle case number C2017-0169. We have respondents listed as Estelle Williams, care of Maggie Williams, Veronica Williams, Janetta Tucker, and Sarah Battle. The violation location is 3920 Louisa Street, and the real estate number is 337360. I'd like to introduce the evidence for our case, please.
Okay.
Mute the volume on your computer now.
Yeah. The way we're going to do this, Ms. Williams, just so you can hear, you should have an email from the city that tells you the
Bridges,
evidence.
just one moment for technology issues. Give me one moment.
Okay.
Yeah, we're having kind of bad weather. I guess that hurricane is passing over, and it's storming now here, so it's kind of difficult. You're going in and out on me.
Okay.
You can actually turn the speaker off. Yeah, but because I have because it's her microphone, it's got to be her speakers. Okay.
Okay, so do you just, where did we leave them?
You just need to start introducing the evidence.
Okay, so I'll share in the chat the exhibit we have.
Okay.
Okay. Chat.
Mr. Bridges, a bit of background on this, just so you know, all exhibits are going to be introduced in the form of a single document, and each exhibit will be described by city staff, and we will go through them using the screen share function.
Okay. Are we ready to go, or are we still doing technology issues?
Ms. Yetter, I believe, is bringing this stuff up as we speak.
Okay.
Andrew, I'll make this easy for you.
Thanks.
Okay. And Ms. Yetter, I believe you said your first exhibit was Exhibit A, if I'm correct.
Yes,
Okay, and I see that's a lengthy exhibit.
yes.
Okay. Why don't we go through it piece by piece, if that's okay? First thing I'm seeing is an affidavit of non-compliance. Is that right?
Yes, sir.
Okay, could you explain that, please?
Would you like me to pull it or to try to send it in chat first
I'm
before
gonna go ahead
it's,
and send it in the
you're
chat.
taking care of it? Thank you. Okay,
And-
the affidavit, I'm sorry.
Okay, one second. Ms. Williams, can you see the affidavit of non-compliance?
On mine with what you sent me or what I'm looking at with you all?
Did somebody send Ms. Williams this, or did she pull it up? I mean, or did Ms. Yetter pull it up? I'm looking at my email that came earlier today.
Mr. Bridges, I just sent it in the chat, so Ms. Williams should be able to access it that way. I'm also going to bring it up on screen as Ms. Yetter
is going through it.
Okay, in that case, I'm going to go back to the main screen then, and so I can see it instead of just looking at my email that way. I think it kind of helps me to see myself, to make sure I don't like pick my nose or something thinking y'all can't see me because I don't see you. So go ahead and bring it up if you would, please. All right. Ms. Yetter, do you see that affidavit up there?
Yes, I do.
Okay, you can take a look at it if you want to. Is
Do
there
I
any
see
legal?
it?
Yes, ma'am. I'm sorry,
No,
Ms.
I'm just-
Ms.
a blank
Jones.
screen, black screen.
Okay. Okay, if you're looking at the Zoom screen right now, you should be able to see.
Hello? Okay, now I see it.
Okay, do you see the affidavit of non-compliance?
Okay, now you're asking me if I see it
Okay.
now?
Okay, now I'm not asking you if you agree with this or not, but is there any legal reason why I should not be able to look at this?
Any legal reason why you should not be able to look at it?
Yes, ma'am.
I don't, I didn't see the order.
No.
It's the same thing. The order provided that in the event.
No, this was my affidavit.
So I'll go ahead. Go ahead. Okay. So Ms. Yetter, you want to go ahead and explain it if
Yeah.
you would?
Yes, thank you. The affidavit of non-compliance was a review of the findings of fact for the hearing that was held on October 16th, 2019, and the requirements therein. Also indicated that inspections were performed that showed that the property was not in compliance with your order from that date.
Okay, but I did speak with someone on last week from your office, and I spoke with my sister as well. And as I was telling you earlier, that they did go over there and they cleaned up the property. And I can't remember her name I spoke with from the office on last week. I had it written down, and she said that she could see where we did go and try to clean up the property and had the lawn cut down. And where I guess where the windows or whatever were broken out, that they were banded up, to keep them out. But basically, she did say that she could see where the property was being cleaned off.
Yes, ma'am,
Had
that
been
was
cleaned
probably
up.
me that spoke with you. But there are other parts to meet
Okay, that was
compliance that
you.
have not been met.
And what, can you tell me what those are? Because I'm not down there. Can you please explain to me what they are?
I tell you what, why don't we let her go ahead and explain the rest of her case, if you would,
Yes.
okay? Okay, so go ahead, Ms. Yetter.
So that was, do you need further information on the affidavit of non-compliance, or would you like me to continue into the exhibit?
Go ahead and continue, please.
Okay, so the next page is the notice of hearing on non-compliance, and that was notification to the respondents that we were scheduled to come today to the hearing to discuss the concerns that we have on the property.
Okay, Ms. Williams, can you see that notice of hearing?
Yes, and as I explained earlier, we couldn't make it today because for one, I live in Savannah, Georgia.
Right.
And I couldn't make it because of the time span and that we're here. I'm here also as well. I work for the health department and
Oh,
we're
okay.
in the middle of COVID. So we have training and not training, we have to go back and forth with that. And we're very tied up with the COVID testing and
Yes, ma'am, and I appreciate all the work, but I'm just asking, is there any reason why I should not look at this notice of hearing? That's all I'm asking right now.
are you saying why you should not look at it? I
Right.
mean, why would you want not to look at it? I mean, I don't understand. I don't want to say something that's I'm gonna be held against. I'm not sure what you mean by that.
It's
Right.
all right. For instance, like if this was a murder trial or something like that, and they wanted to present the gun to the judge, the defendant would have an opportunity to say, no, you shouldn't look at that because, it was illegally taken or something. Is there anything illegal about this this notice that you know of that would mean that I shouldn't look at it. I mean, to be honest with you, I can't think of anything, but
I can't either. I mean,
Okay.
I guess because you all already sent it to me, so I'm pretty sure it has already been reviewed by some of you. So
okay,
I mean, I'm seeing parts and bits of it.
okay.
Um,
Basically,
is it, like, can I not let you look at it and then let the rest of my sisters look at it and then we get back to you, or?
well, I don't know that we can continue it. You can object to my looking at it if you want to. And if you have a legal
Okay,
reason.
well, I don't know.
You can object if you want to. I'm not going to take it personally. Do you object?
I mean, would it hurt in the meantime, in the long time? Because see, I really don't. I mean, what is it specifically when you view it? What specifically are you looking for?
Well, I can't give you legal advice. All I'm saying is part of the city's case is saying that they gave you notice. Now, you might not think that's good notice. It might not be valid notice, but part of what they are doing is they're saying we gave notice, and this is their evidence that they gave notice. If there's any legal reason why I shouldn't see that and take it into consideration, I'm going to let you have your case in a little while. Then
Okay.
just say I object.
Okay. Well, at this time, I guess I do object.
Okay.
I don't know.
Okay, I don't take it personally. Now, don't take this personally. Overruled.
Okay.
Ne-
Don't.
next-
I'm sure.
okay. So next exhibit, please.
Your Honor, in order to go ahead and save some time here, I'm going to go ahead and ask Ms. Yetter just a few questions before we go through the rest of the exhibits, and that may go ahead and clear a few things up here.
That's fine. Go ahead.
Ms. Yetter, are you aware of the respondent in this case, Estelle Williams, and the other owners of this property having been taken to a code enforcement hearing by the city of Marathon on October 16th of 2019?
Yes.
And what occurred at that code enforcement hearing?
The respondents were found in violation of City of Marathon Code and were provided with orders.
And it was
Are you aware of what relief was awarded by the magistrate during
during
the
the
code
code
enforcement
enforcement
hearing?
hearing?
Or what requirements the respondent was required to comply with?
Yes.
And what were those requirements that the respondent was required to comply with?
To apply for and obtain building permits for all repairs necessary to make the structure safe for its intended use as designed by a Florida licensed architect or engineer, or applying for and obtaining building permits to demolish the structure within 30 days and cause the actual repair or demolition to occur within 6 months of receiving said permit. And also that in the event the violation was not corrected by the date set for compliance, which is November 16th of 2019, the respondent should pay a fine in the amount of $100 per day for each day that the violation continues to exist past the compliance date and retroactive to the date of the hearing, October 16th, 2019, as well as to pay an administrative fee in the amount of $300 within 30 days of October 16th of 17th of 2019.
Are you aware of whether any of the respondents applied for the permits that they were required to comply with or demolish the structure as required by the order on
October 16th of 2019.
No.
And when you say you're not aware, are you aware whether they applied for a permit or not?
I am aware that they have not applied for a permit.
Okay,
I'm going to turn the floor back over to you.
Have you through the rest of your exhibits, Ms. Yetter?
I'm sorry, sir.
You want to go ahead and take me through the rest of your exhibits?
Yes, thank you.
And Ms. Williams, you'll want to look at your screen too, okay?
Right.
So after the notice of hearing that was provided, we did not receive good service for the notice of hearing. So we posted on the property itself on September 4th, a notice that the hearing would be taking place.
Okay. Ms. Yetter, any legal reason why I shouldn't look at this?
No, go ahead.
Okay, okay, thank you. Admitted. Go ahead.
Okay, and next I do have certified mail showing that after I posted the property, there were notices that were delivered by certified mail. So we've included those as well for completion.
So are you saying that you sent mail to us since November in reference to this? A
Well,
reference?
let's just go through her, let's
Okay.
just go through her exhibits first, and I'm gonna let you ask her all the questions you want, okay? Ms. Williams?
Okay.
Okay, any reason why I shouldn't look at the certified mail exhibit? Yeah, I'll take that as admitted. Go ahead.
Mm-hmm.
And we also have included the certified mail receipts showing what was mailed, even though we did not receive good service on those
Okay.
particular pieces of mail.
Okay.
And finally, I have photos taken of the property since June of 2020, showing its status on those dates.
Okay.
So this photo was taken June 10th. It's another angle from June 10th.
Did you take the photos?
Yes, I did.
Okay.
June 10th as well.
Mhm.
Another from June 10th. June 10th. June 10th. Also June 10th. And last one from June 10th. And then took another set of photos July 7th. This is from a different angle, also July 7th. Finally, another angle on July 7th, and then photos taken August 17th. And from the front of the structure on August 17th.
Okay.
And then another on August 17th from a different perspective. And another of the structure on the 17th
Yes,
of
ma'am.
August, and then finally showing the posting of the notice of hearing on the property itself. And so the last piece of the exhibit is a listing of the sheriff's office call log for the County of Monroe. And these calls began from June of 2013, or January of 2013 through June of 2020, showing the deputy and other sheriff's department personnel's responses to this address.
Okay, is that, what is the relevancy of that?
We wanted to ensure that the concerns regarding the unsafe status of the structure and its potential impact on the neighborhood and the people present on the property was available.
Okay. Anything further as far as your exhibits?
No, sir.
Okay. Ms. Williams, is there any legal reason why I shouldn't look at all those things and consider all those things? You're allowed to put in exhibits too if you want to, but is there any legal reason why I shouldn't look at these exhibits?
No, and when you get them, I need to see them because I never saw that.
I'm seeing them for the first time myself right
Yeah.
now. So
Okay.
I'm going to go ahead and admit all of them except for the sheriff's call logs. I'm not trying to advocate for Ms. Williams, but I have a problem with seeing the relevancy of that at this point. So, but everything else I'll admit. Okay. And anything further you wanted to say, Ms. Yetter?
No, sir.
Okay. Ms. Williams, Ms. Yetter has basically said that last year y'all were found in violation and that you were told to get a permit within 30 days and y'all did not permit, that the building still has the house still has some structural issues that I believe were exhibited by the photographs, and that they're asking me to assess the fine that I said I would assess last year if it wasn't done, which is $100 a day from October 17th, 2019 through until it gets done. That's basically what Ms. Yetter's argument is. Would you like to ask Ms. Yetter any questions, or would you like to call some witnesses, or would you like to make a statement yourself or show some exhibits?
Well, I just wanted to ask you because, honestly, I don't remember. She might have, but I don't remember any from last year, but I know that we did get a letter. I did get a letter stating to come July 16th for this hearing here because of the non-compliance of the building. But I don't remember last year. She said from last year we were getting notices about this.
Mhm.
And then again, did she send me one?
Well, they send the registered owners of the property.
Yeah,
notices.
because, and she sent one to me in Savannah, Georgia.
Well, I don't want to go back and relitigate last year's hearing because
Yeah,
last
okay.
year we had a hearing and we went through all of the notices and everything at that point.
Oh, you did?
I don't remember if anybody was responsible.
Yeah.
Okay, but just as far as this hearing goes, anything you would like to say in defense?
Well, the only thing I can ask for, because see, you're saying something about $100 a day, and I'm asking that you please waiver this because, like I said, I'm in Savannah, Georgia, and I'm working 2 jobs, and I don't get all the information like I need to. And then sometimes when I do get it, it's like at the last moment, like I have not a good time frame to respond to do what I'm supposed to do. And then I'm working with 5 other people. And it's like I'm taking on this irresponsibility now. So I'm just asking, I'm pleading at your mercy. That's all. In all honesty, I'm pleading at the mercy, at your mercy of what I can do.
Okay.
We're trying to keep
Mr.
this
Bridges, may
property.
the city, no.
Yeah, I'm gonna give you a rebuttal in a second. Go ahead. Go ahead, Ms.
We're-
Williams. Anything else?
We're trying to keep this property that my daddy so hard worked for. And we are born and raised in Marathon. My dad was a big time contractor there, and this is what he worked hard for, and we're just trying to keep it. And it seems like it's just the hardest thing. And it's like now I'm the youngest of 6 girls, and I'm trying to keep up with it, and so we can do what we need to do with it. And it's been I know it may sound like a sad story, but it's the honest, godly truth.
I believe you.
And it's just getting to the place where it's overwhelming.
I
And
understand.
we're trying to, I'm trying to do.
Okay.
Mhm.
Was there anything else you wanted to say, Ms. Williams?
Not at this time.
Okay. Mr. Jones, you'd want to say something or?
Yes, Your Honor, just a brief rebuttal in closing on behalf of the city. The findings of fact, conclusions of law and order were actually signed by you, Mr. Bridges, recorded electronically in the public records of Monroe County on December 10th, 2019 at book number 2998, page number 839. As Ms. Yetter just testified to, this order did require compliance with a violation that was found last year. It did assess a fine of $100 a day for each day that passed beyond the compliance period of November of 2019. We haven't seen compliance, and that is the city's main goal here. But as you know, we have very limited tools available to us to enforce the city's codes here. So at this time, I would ask you to assess a fine of, I believe, $33,900. That would be 336 days that have passed since the October 16th hearing. As reflected by the order, if we go past the 30-day compliance period, the fine would apply retroactively from the date of the hearing. And for Ms. Williams's benefit, I imagine that there may be some sort of agreement that can be worked out with regard to these fines, but the city does ask for it to go ahead and be levied at this time, so we can try to work with Ms. Williams to go ahead and bring this property back into compliance. And that's,
Thank
it
you.
would rest at this
All right.
point.
Thank you, Mr. Jones, and thank you, everybody.
I
Ms.
do have one more question.
Sure.
When you said bring it up, can you tell me exactly what do you want? What are you expecting as bring it up to compliance? What are you expecting as?
Okay, what I'll ask you to do is after the hearing, contact Ms. Yetter, and
Okay.
she can go through all of that with you, okay?
Okay.
A few minutes ago, Ms. Williams said that she was afraid that what she was saying was going to sound like a sad story, but the truth is, it is a sad story. There's nothing fun about these kind of things. Unfortunately, mercy, so to say, was extended back in October of last year when the owners of the property were given 30 days to pull a permit and start getting into compliance. And had they done that, there would have been no fine at all, just a $300 administrative fee. But unfortunately, it doesn't look like much has been done, and the permits certainly have not been done. Once a permit is pulled, usually you have 30 days to get it taken care of. And I realize that getting things like this, structural damage, taken care of can be expensive, sometimes prohibitively expensive. Sometimes the property might even have to be sold, but there's simply no other way to enforce the Marathon city code other than through some fines that unfortunately after a while do inflate to large sums. That's a dangerous structure right there. It's unsafe. Nobody should be in it. It becomes an eyesore. And frankly, while I do have sympathy for Ms. Williams, and I know you're working hard up there in Savannah, and it sounds like you're kind of the caretaker of your family and all that. The bottom line is, whether somebody is well off or barely making it, the people of Marathon have a right to enforce their codes. So I'm going to go ahead and agree with what the city has said. I'm going to assess the fine at $100 a day, dated back from October 17th, 2019. I believe Mr. Jones said that was $33,900. Ms. Williams, you do have 30 days to appeal this to the circuit court if you want to. And I'll also tell you that once you have pulled the permit and begin cleaning this property up, you can contact the city and you can ask to mitigate this fine and reduce the fine. Code enforcement is not really here so much to fine people as they are just to enforce the codes. It's my experience that they usually will, and it's not up to me at this point, but they usually will reduce the fine if you get into compliance. And of course, they're allowed by city statute to reduce the fine a certain amount if you get into compliance very quickly versus a lesser amount if you get into compliance at a later date. So that's what I'm going to go ahead and do in this case. And is there anything further? We'll go ahead and assess the $300 administrative fee for this hearing, which we're required to do. And so that's what we'll do in this case. Good luck to you and God bless you. And we'll go ahead and move on to the next case, please.
Mr. Bridges, just so you know, for the record, I do believe Ms. Williams dropped off the call sometime mid in your speech.
I think she did too, but so thank you. Our next case looks like it's C 2019-0088, non-compliance. The respondent is Joe's Seafood, the registered agent of which is Maria Veloso. And this is a construction of exterior stairs and deck without benefit of a permit, I believe. So do we have anybody for Joe's Seafood?
Can you see me? Hello, how are
Yes,
you?
sir. I'm very well, thank you. And who is that we have from the city on this one?
First name Danny, last name Yero, Y-E-R-O.
Okay, what I'll do is, okay, Mr. Yarrow. And who's prosecuting this on behalf of the city?
Ms. Yetter will be prosecuting on behalf of the city.
Okay, Ms. Yetter, you want to go ahead? Mr. Yarrow, what I'm going to do is I'm going to let the city go first. And I'm going to let you object any exhibits that they have, and I'm going to let you ask them questions and then put on your own case, okay? So
For
go
Mr.
ahead, Ms.
Harris,
I am going to send in the chat, which he should have access to at the podium, a copy of the city's exhibit so he can flip through it as we're going through this.
I've got it.
Oh, and I have been informed by city staff that a paper copy has been provided as well.
Okay, Ms. Yetter, you're still under oath, so go ahead.
Thank you, sir. As you mentioned, this is case C 2019-0088. We have respondent Joe Seafood Incorporated, registered agent Maria Veloso. The violation location is 520 12th Street, Gulfside, and the vacant land at 12th Street, Gulfside, with RE numbers 101610 and 101610-000300. At this time, I'd like to introduce our exhibit for evidence, please.
Okay, I didn't want to go through it piecemeal like last time.
Yes, thank you. So initially, or the first page we have here is the affidavit of noncompliance. It reiterates the findings of fact from the September 18th, 2019 hearing with yourself, and also with regard to the re-inspections that were conducted at the property, showing that all items had not been complied with.
Okay, and Mr. Yarrow, do you have any legal reason why I should not be able to look at this affidavit? I'm not asking if you agree with it, but I'm just asking, is there a legal reason why I shouldn't look at it?
You can definitely look at it, sir.
Okay, thank you. Go ahead, Ms. Yarrow.
So next we have the notice of hearing on noncompliance, which is just notification of the date and time of today's hearing,
Okay,
as well as a copy of the City of Marathon Code section,
okay,
along with the proof of mailing, which we did not receive good service for. Therefore, we did post the property. I posted the property, and I've included a copy of the posting notice as well as the affidavit of posting the notice of hearing for today's meeting.
okay.
Lastly,
Ms.
I have photos taken
Hold on one
since
second,
October.
Mr.
2000.
Yarrow, is there any reason why I shouldn't look at these, the postings and the attempted service?
Yep, fine with me, sir.
Okay, thank you.
Thank
Go
you.
ahead.
Sorry. And now I
That's all
have
right.
photos taken since October 29th of 2019 of the property in question.
Let's go through these photos one by one.
Yeah, why don't we go through these one by one?
Okay, so this is from the front of the, this is from the right of way, the front of the property, including the vacant land, all taken October 29th of 19.
Okay,
And a slightly different section of the vacant land, including the driveway and showing the property itself, taken October 29th of 2019. This is a corner of the property. You can see a corner of the house there, taken April 23rd of 2020 from the driveway. This is a section of fencing. Photo was taken April 23rd of 2020 from the driveway. We have the structure itself, photo taken April 23rd. And the close-up photo showing not only the deck and the stairs, but also the posting notice that was put on the property on September 4th. And that is the end of my exhibit.
okay, Mr. Yarrow, is there any reason why I shouldn't look at those photographs and consider them?
You can definitely look at them, sir. Yes, sir.
Okay, thank you. Ms. Yetter, is there anything else you'd like to say?
Substance of the order.
The findings of fact that were identified or that were put into the record on September 18th of 2019 required the respondent comply with 3 separate sections of Marathon Code, section 22-24, section 18-28, and section 6-52. So these sections relate to high grass and weeds, to fencing condition, as well as to permits required for alterations done on the property. And the requirements were to include mowing and maintaining the property, removing the damaged fencing, or applying for and obtaining permits to replace the fence, and applying for and obtaining permits for the stairs and the deck within 30 days from September 19th of 2019. So via inspection, we found that the mowing and maintenance of the property's grass and weeds was acceptable and in compliance. We did find that the fencing was repaired and removed on the front of the property to bring it to compliance, but that there remains no permit on file for the deck and stairs that were constructed.
Anything else?
Fine.
The order also required payment of the $300 administrative fee for the hearing itself, as well as fines of $100 per day to accrue from the day that the violation continued past the compliance date.
Okay, all right, and anything further?
Not from Ms. Yetter, just I would represent to your honor that the findings of fact, conclusions of law and order in this matter signed by you on the 26th day of September 2019 were recorded in the public records of Monroe County on October 23rd, 2019 at book number 2990 and page number 1731.
Okay, and Mr. Yarrow, I'm going to give you a chance now. Since cross-examination sometimes morphs into testimony, let me go ahead and swear you in. Do you solemnly swear or affirm that any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, at this time, would you like to ask Ms. Yetter any questions?
Well, I just need to bring clarification because I've only spoken to Ms. Yetter once before. Very, very nice. But I was working very closely with Ms. Childress before, and there's a couple issues based on some of the things that Ms. Yetter said that I don't know if Ms. Childress ever put into her notes. One was you may have this from the previous minutes. This was a Hurricane Irma claim. The insurance had not paid out. The insurance was actually negating all the issues with the claim. The last time I spoke to Ms. Childress was, I can't recall, I want to say January or February before Brexit. I didn't even know that she had departed. She had asked me to do various things, which was some of the ones that Ms. Yetter said, which was the mowing. We had also had a problem that I had contacted Ms. Childress on. We were getting people dropping off, illegal dumping, boats, cars that were parking that were not Joe's Seafood, the Maria Veloso stuff. We got all of that taken up. We have a local company cutting the grass every 2 weeks. She also asked me, there were tenants there, that it would be better if I got rid of the tenants. That way it wasn't an unsafe structure for them. We did, we removed all the tenants. Then there was the issue of the fence in the front and the fence in the back. The fence in the front, it was down, so we just removed it, but the fence in the back was not ours. It belongs to the neighbor. She was going to address that with the neighbor. It's in one of the pictures that Ms. Yetter just showed from a corner. So Ms. Childress says she was handling that with our neighbor, because when we went to talk to them, he said, no, he wasn't going to deal with us. And then the other thing she had to do, she said that a concerned citizen had called because the building just looked bad. If I could paint the building white on the face that was coming from the street in. And I said, okay, we did all those things in compliance here. And then she had me board up so no one could go up and down the stairs, which it's in Ms. Yetter's pictures. Yeah. So when we finally did settle with the insurance company that gave us a portion of the funds, not everything, because it's still ongoing in litigation, I told Ms. Childress, and again, I'm not sure if it's in her thing, we're just going to demo the whole property. So we were in the process of doing that, and then COVID hit. And when COVID hit, everything just basically went to crap. Now I've sent, misuse a word, I actually sent in my contractor registration. I sent out paperwork, and I sent in a small drawing of what was going to get done. And I think I spoke to a lady by the name of Maria. That's the name I recall. I don't have those documents here with me. I did rebring everything again. So what I had discussed with Ms. Childress, and I believe I told Ms. Yetter last time I spoke to her, the property is going to be demolished. That's our intent now. It's not going to be, but everything that Ms. Yetter, with the exception of pulling the permit for the stairs, it's not done because the entire property is going to be demolished. So that's where we stand right now.
Okay. Has the demolition permit been pulled yet?
No, I have all the paperwork here because what I did send in, apparently, according to Maria, only the contractor registration made it in, and the liability insurance was not done, and they didn't accept the one pager that I did. We've got a lady by the name of, she's a local lady, Gay Marie Smith. It was a permit run. I don't know if you know who this is, but that's who's handling this now for us to be able to do the demo permit. I've got my crew and Mr. Sweet from Affinity Homes, one of his subs, to help us out. So as soon as the building department, and I know that things happened with COVID and there was a big turnaround, as soon as we can get an approval, this thing is, something just happened, the screens just switched.
Okay, I see you now.
Okay, all right.
I hear you, so go ahead.
Okay. So yeah, so that's basically the audit. If I can get some guidance from someone here now, I've got all the paperwork here, I've got everything here. All we're looking for now is to do the demolition, and that's it. That's basically where I'm at right now. But everything else that she asked me, that Ms. Childress did, and I don't know if anyone has access to her files or not, was done, and how we proceeded on doing it. And if you don't have it, I can look for those emails and text in the morning.
Okay, that's fine. Anything else you want to add?
Nothing I can think of right now.
Okay, does the city have any response?
Yes, Your Honor. The order and the findings of fact that were previously discussed during our case in chief required the respondent to apply for and obtain permits for the deck and stairs, and that is the one thing we can objectively say has not been done. As unfortunately with Ms. Williams, the city is left with very limited options on how to enforce its codes. We would ask that the fines be assessed, but I'm sitting across the table from Ms. Yetter and Mr. Lewis as we speak. And I do believe there's some solution that can be worked out here, but I think unfortunately the first step is we do have to ask for the fines to be assessed. We would ask the respondent to try to get in touch with the city as soon as possible. And I believe that something can absolutely be worked out if we can get a demo permit applied for in the next 30 to 60 days. But unfortunately, the city is in a position at this time. We do have to ask for the fines to be assessed. The previous order set October 19th, 2019 as the date for compliance with a fine in the amount of $100 per day. For each day, the violation or violations had continued to exist past the compliance date. So by my calculation, that puts us at 364 days, just shy of a year of days that have accrued since the compliance date. At $100 a day, I calculate that to be at $36,700. We would ask for that to be assessed in along with the administrative fines for this. And we can hopefully try to work something out with the respondent if his intention is to go ahead and move forward with demolition of the property. As you mentioned with Ms. Williams, the city code department's main goal here is just to ensure compliance with the city's code. And with that, the city would rest.
All right. All right. Speaking of Ms. Williams, I notice you're still here. You're certainly welcome to stay. This is a public hearing, but unless you've got another case, you don't have to be here. You're free to go. And you're on mute right now. You're on mute. You're on mute.
Can you hear me now?
Yes, ma'am.
Okay, the only reason why, because I was kicked out, I guess because of the weather at the last minute when you all were going over the last part and I didn't get the last information.
Okay, I tell you what, hold on one second and let me take care of this case and then I'll come right back to you, okay?
Okay.
All right. Mr. Yarrow, thank you very much, everybody. Mr. Yarrow, I agree with a lot of I understand you complied with several things, including the fencing, part of which might not have even been yours. You got the grass mowed and everything. The permits, you obviously have not been complied with. The requirement to pull the permits have not been required to be pulled yet. And I understand that financial issues may make that impossible because you have to have a contractor who will pull the permit most of the time and they want to be paid up front. The city is correct, though, that this is probably a case that we'll call out for mitigation at a later time, but I don't really have.
Second, based on something you just said, the problem, what I was dealing with Childress, because I actually had her meet with me and another gentleman from, I guess, your building and zoning, I forget that gentleman's name, the architect, the engineer, and the insurance adjuster. We all met at the property because the problem was that, and I don't know how familiar you are, and I'm sure the attorney is, when it comes to the insurance, if we touched the building before the claim was settled, then basically you renege on what your potential damages are for recuperation from the insurance funds. This is why Ms. Childress was working alongside with me to get it, and we finally we even got a portion. We're not going to get enough, obviously, to rebuild the building, so that's why we made the decision but I was in close contact with Ms. Childress. Again, if you check her records, constantly doing everything possible to lead up to this point, because we would have shot ourselves in the foot if we had removed anything, because it was just we're caught in the middle between Mr. Big Bad Insurance Company and what occurred with the storm.
I understand what you're saying. And the good news, I got good news and bad news for you. The good news is the city of Marathon has a mitigation program where once this is pulled into compliance, once we've got the permits pulled and the work is done, you can come back and ask for the fine to be mitigated. The city staff will mitigate it to a certain amount. It can come up to me if you're not happy with what they did, and they can mitigate it. And ultimately, you can even appeal to the city council and ask them to wipe the fine completely out if you want to, and make the case to them. And this certainly, you may be able to make a very compelling case. The only thing that is in front of me today is whether the property is in compliance, which it isn't. I mean, I don't think you're denying that either. You've got some reasons why it's not, but the only thing that's in front of me today is whether it's in compliance. And of course, way back when, we assessed $100 a day fine if it wasn't in compliance. So therefore, my choices are a little bit limited here. It is a $36,400 fine plus the $300 administrative fee from last time, plus the $300 administrative fee from this time. Again, you may very well come back here on a mitigation issue, which you're certainly welcome to do. Anybody is welcome to do that. But for right now, since it's not in compliance, I just have to follow what the law says and find it in non-compliance. I'm sorry that I know that's not the result that you wanted today, but I wish you the very best of luck. And the faster you get it in compliance, it's my experience, the faster you get it in compliance, the faster, the more mitigation you'll probably receive.
Well, like I said,
Okay?
I have the paperwork here. Who do I need to see from the building department? Because again, for me, I just need you to understand me. It became very, very frustrating because of the whole COVID thing, and then Patty
Yeah.
leaving, then everything just got convoluted. And I didn't hear from Ms. Yetter, I want to say until last month, whenever I spoke to Ms. Yetter, they didn't even know someone had been assigned to the file, because when I spoke to Maria, last time she transferred me over to a building official back in March, I want to say, February or March. So
I see Mr. Lewis is here. Do you want to unmute yourself and maybe tell him exactly who he needs to see?
Mr. Lewis is who he needs to see.
Okay.
Yes,
Yeah, Doug Lewis is the man
come
he
in
needs to see.
to see me, and I will direct you through. I'd also be the one you would mitigate and negotiate with to mitigate these fines.
Okay, and where do I see Mr. Lewis at? Right here through these doors? Right there? Okay. Okay.
Unfortunately, Mr. Yarrow, just not today because we are in code enforcement, but I believe Mr. Lewis will be here for the rest of the week. He's going to have to sit here with me through the rest of these hearings. But
Okay.
after the hearings are concluded, he will be available to speak with you.
Is there a business card or something in this office that I can get for him so I can get everyone's emails?
We can certainly have a business card left for you at reception. I think somebody is going to bring it out to you right now.
All right, great. Thank you very much.
Thank you, Mr. Yarrow. Good luck to you.
Thank
Okay.
you.
Turning back to Ms. Williams, basically what we did was we mentioned that there had previously been a finding of violation, and the owners were given 30 days to get in compliance. The only issue that is in front of me today is whether compliance occurred or not. It obviously did not occur. You may have some reasons why it didn't occur. I certainly understand that. But so I went ahead and I agreed with the city's request to impose the fine of, I believe it was $33,900, if I'm correct. Ms. Williams, like I was telling Mr. Yarrow a minute ago, if y'all get this into compliance in a very reasonably quick way, then you can always come and ask for a reduction of the fine. You can work with Mr. Lewis to get the fine reduced. If you're not satisfied there, you can come to me and ask to have it reduced. I have certain guidelines I have to follow. And if you're not happy with what I do, you can always go to the city council and ask them to reduce the fine. They can take the whole fine away if they want to. But in any event, there's 30 days that you can appeal this decision to the circuit court if you want to go that route as well. So, okay. And thank you, ma'am. You're on mute right now. You're still on mute. Okay. Okay.
Can you hear
Say
me?
something. Yes, ma'am. Not anymore. I'm afraid you're going on mute. So
Okay, how about now?
very good.
Okay, now, I would like for you to go, if you can go for me in front of with the judge, because to see if you can waiver these fines because of the COVID, and we don't have anyone down there, so we would have to have found someone to come down there to do that. My older sister did, my older sisters, I don't know if one or two, they did send in a letter stating that they're 67 years old and she does have invalid child that she has to take care of. So we couldn't get down there to do that.
I understand.
So-
Ms. Williams, if you're asking me if I can go in front of the judge, I can't do that. I'm not allowed to. You might want to hire a lawyer in Marathon and talk with them, and they can help you, okay? All right, you're on mute again. So, okay, so we'll go ahead and we'll move on to the next case. And that case will be, looks like case number 2017-02. Oh, that's been withdrawn, excuse me. Our next case is 2017-417. The respondent is Errol Williams.
Yeah.
Errol Williams. Do we have anybody for Errol Williams here?
Yeah. Oh, no.
Is that you also?
No, I'm sorry. I just needed I'm sorry to keep interrupting. I just need a number where you said that I can go to someone to see if I can get it waived or reduced, that number.
Ms. Yetter, you want to give that to Ms. Williams? Mr. Jones?
You can call me, Ms. Williams, and I
Yeah.
can get you in touch with Doug. My
Yeah.
telephone number is 305 289 5024.
Okay. And you're the one I spoke with last week?
Yes, ma'am. I'm
Okay,
Angela.
thank you. Yes, you're a nurse. She's nice.
Okay. All right, we'll go ahead and move on to 2017-0417. This is a new case. Errol Williams is the respondent. The allegations are roof repairs without the benefit of a permit. Is there anybody here responding for Errol Williams? I see a very happy man at the public podium, but that's all I see.
Not
Not related to Estelle Williams.
I
That's
believe.
right. Okay.
There's nobody on the call, and I would just ask Brian to confirm that if there's anybody in the city council chambers on behalf of Mr. Williams.
And Ms. Williams, you're free to go if you want to. You can stay if you want, but you're free to go. Your case is done. Okay, and we don't have anybody in the chambers for Errol Williams?
Brian, can you please confirm whether there's somebody in the room for Errol Williams?
Yes, because we're waiting. He's told me he was there. But the rest of the updates, the only one.
Well, hearing nobody approaching the podium, I do not believe there's anybody here for Errol Williams.
Ms. Yetter, it looks like you're the code enforcement officer on this one.
Yes, sir.
You're Miss Popular today, aren't you? All right, you're still under oath, so go ahead, please.
Okay, thank you, sir. This is, as you mentioned, case C2017-0417, the respondent Errol Williams, inspectors myself. Violation location 398 116th Street. The real estate number is 346050. And if I could, I'd like to introduce evidence, please.
Sure, go ahead.
And as we don't have any respondent to object, would you like me to just go through?
Yeah, just go ahead and go through it.
the items. So initially, we've got the property record card, just reflecting ownership and location. I have the City of Marathon Code section, which is 6-52 regarding work without permits.
Mhm.
Next, I have the notice of violation that was sent. The certified mail receipt, there was not good service. And so the property was posted on September 28th of 2018. You'll see the posting notice here, as well as following the affidavit of posting of the notice of violation.
Mhm. Okay.
And then the following page is the notice of hearing for today's meeting, as well as the certified receipt and proof of delivery from the Postal Service.
Okay, so that was delivered.
Next, we've got photos from the property in question. This image was taken December 27th of 2017 and showed a worker actively working on the roof. Another photo taken December 27th of 2017 with the front of the property and the mailbox address. The next photo also taken December 27th, 2017 with the dumpster and some indications of the location of the dumpster with the property. The next photo was also taken December 27th of 17, just reflective of the properties or the vehicles on the property working on it. Next, we have a photo taken September 28th of 2018 showing the posting notice of the notice of violation, as well as the next photo, the same date, showing the location in a wider angle of the posting notice. And the most recent photos taken August 20th of 2020, you can see the current status of the property. The posting notice has been removed from the front door. The next photo is August 20th. You can see that there is a power meter present on the property. and just a wider angle view of the photo or of the property taken August 20th, showing its current status.
Is that the last of them?
That is the last of the exhibits. Yes, sir.
Once again, is there anybody here for Errol Williams to object to these being admitted? And nothing is heard, so they'll be admitted. Looks like we got pictures of everything but the roof. Okay. Anything else you'd like to say?
We did have communication with the owner in City Hall, in addition to an on-site discussion with the workers. They were told to suspend work until a permit was pulled. So the owner should be well aware that permits were necessary for the work that he had performed. And still has not requested those permits. So we'd just like to see if we could receive an order for violation of section 6-52 on this property, as well as an order for permitting to be pulled and approved for the after the fact permits, I should say, for the work that was completed. We'd like those to be requested and obtained within 30 days with an actual completion of the permit within 60 days. And we'd also like to request an order for the respondent to apply for and obtain permits for any work begun or that's otherwise deemed necessary within 30 days from the date of the hearing, as well as an administrative fee of $300 for today's hearing, in addition to fines of $100 per day for violations that continue to exist past the date set for compliance.
If I may ask a few questions of Ms. Yetter before the city can rest their case.
Ms. Yetter, did you personally
Observe work being performed on the roof of the respondent's property?
I did not personally.
Were you made aware of, how were you made aware
Aware of work being performed on the respondent's property on the roof?
Case file and documentation from the code officer that witnessed the work being performed.
Which code officer witnessed that?
That was Patty Childress.
Okay, and why is Ms. Childress not here testifying before us today?
She no longer works for the city of Marathon.
Thank you.
All right.
City
Ms.
rests
Yetter,
their case at this-
in any of your conversations with the owner, did he acknowledge doing work on the roof?
I did not speak with him. The conversations held were with the prior code officer.
Okay, and this is in her notes or something, and did he admit that he was working on the roof?
I don't believe that there was a specific question asked of him for an admission of work on the roof.
Mr. Bridges, if I may ask just a follow-up question.
Sure.
Bring one of the photographs that was introduced into evidence as city's exhibit D.
Right at the good part, it froze. I didn't hear what your question was.
Apologies, I said I would like to just share my screen real quick to show one of the photographs that was introduced as
Yeah.
exhibit D.
Ms.
Can
Yetter,
you expand that any? Or
Yes, I can.
Page 1 of 9.
Ms.
Ms.
Yetter,
Yetter, can you take a look at the photograph that I have up on screen?
Yes.
did you personally
Have any conversations with Ms. Childress, or were you able to see any notes from Ms. Childress about exactly what we're seeing in this photograph?
Yes.
And what were those notes or what
What was the conversation?
The notes reflected that a contractor that was nearby doing work for another homeowner had come next door and begun work on repairs of this subject roof.
Okay. And are, excuse me, are those notes from Ms. Childress in this document somewhere?
No, not in this exhibit. Yes.
We
Send it to me.
Yes.
do you want to make those an exhibit, the notes?
I would like to introduce Ms. Childress's code enforcement notes as an exhibit, Mr. Bridges. However, I believe they're
not readily
available at this time.
Are you asking to continue the hearing?
I'm not asking to continue the hearing. If Your Honor is willing to give me 1 or 2 minutes for the city to
Sure.
And to go
Sure.
ahead and
introduce them at this time.
That's okay. We can take a break if you want to.
If we could, why don't we just take a 5-minute break? I would appreciate a glass of water anyway.
Okay, very good.
Would it be? Okay, pull it off.
And we've located the notes, Mr. Bridges. I'm just getting Miss Yetter back in here to explain what we're looking at.
Okay.
No, because of the pictures of people there, it was a- took them all, pushed them all over to the home. So that was mine when I salvaged. Okay.
Okay, Mr. Bridges, I have just uploaded a document into the chat, which I'm going to bring up on screen now.
Okay.
Miss Yetter, do you see the document that I have up on screen?
Yes, I do.
What is this document?
These are our case notes for each individual code case.
Can
Can
you
Explain briefly exactly how this document is created as a business practice of the city of Marathon, just in general.
As you can see, the case number is listed 2017-0417. That indicates the case number assigned to the address listed above in the location 398 116th Street. And so as we perform activities related to this particular case, we document what is done, conversations held, actions taken.
Okay, I'm going to draw your attention to what I see is listed as a note on the second page. Can you tell me what we're looking at here?
Yes, actually, if you could just scroll up a little bit, the note text there refers to a date performed December 27th of 2017. It's noted as an initial inspection completed by Patty Childress.
And did Ms. Childress leave any notes reflecting her observations from December 27th of 2017?
That's the free text here. It says 3 people on the property, 1 on the roof, 1 in a Keys contracting shirt digging a hole, and 1 in a Roberts general contracting shirt. Dumpster out front, interior demo, said they were working with Keys contracting on the house next door and started the demo for the owner while he gets permits.
Have you had a chance to take a look at the city's permit records with regard to the respondent's property?
Yes.
Or is there any record in the city's records of the owner obtaining a permit for the construction on the roof as it's described in Ms. Childress's notes prior to December 27th of 2017?
No.
Your Honor, we need to move into evidence what is labeled in the chat as document 0417. And I'd like to move that into evidence as part of the city's case.
Again, is there anybody here for Errol Williams? All right, they're admitted.
And with that, Your Honor, I would rest as a closing. I would point out that we do have official records of the city of Marathon indicating that
former code enforcement officer Patty Childress made observations on December 27th,
2017
that work was being done on the roof.
we have also introduced
photographs that Ms. Childress took
from her observations on the property that day.
It does clearly show contractors on the site
and that work was being performed on the roof.
You've also heard some
Testimony from Ms. Yetter indicating that there is no record in the city's file
of a
building permit having been pulled for that property, reflecting the work that was being performed on December 27th of 2017.
With that, we believe that there has been a violation of the city code. We would ask that you find the property
violation of that provision, that you require the owner to apply for a after the fact roof permit
within 30 days, as well as a permit for any unpermitted work on the property, with a fine in the amount of $100
a day to accrue on the property for each day that is passed beyond that compliance period.
Okay, much of the evidence in this case, of course, is hearsay. However, hearsay is admissible in administrative hearings as long as it's supported by substantial competent evidence. And after hearing all this, I do think there is substantial competent evidence that this gentleman was having work done on his roof without a permit. Therefore, I'm going to go ahead and find there is a code violation here. Direct that the respondent apply for an after-the-fact permit for any unpermitted work, up to and including work on the roof, assess a $100 a day fine. And what did you want the compliance date to be? 30 days, is that right?
30 days from execution of the order, Your Honor.
30 days from execution of the order will be the compliance date, and an administrative fee of $300 is assessed. Anything further on this one?
Nothing further from the city on this one, Your Honor.
Okay, then in that case, we will go on now to case number 2018-440. This is, respondent is Mariners Place Land Corporation with Carlos G. Burdeel, the registered agent. So is there anybody here from Mariners Place Land Corporation?
Your Honor, because we do apparently have at least one respondent present at City Hall, we were wondering if we might call, which one is this? We would ask if we might call out of order 2019-237, but that is completely up to Your Honor.
That's fine with me. That's actually considerate. I'd rather be able to do that with the people who are actually waiting. So yeah, let's go. Go ahead and do that. Okay. And let me see, which one was this that you want to go ahead and call?
2019-237, Your Honor.
Okay, that's going to be respondent Charles Wallace Butner II and Nadia Butner. And this is 409 James Avenue. We're calling up 2019-0237. Violation alleged is ongoing construction of downstairs enclosure without the benefit of a permit. And stop work order was issued for said violation. So who do we have here for Charles Butner and Nadia Butler?
Charles Butner, sir.
Okay, hello, Mr. Butner. Am I saying your name correctly?
Yes, sir.
Okay, all right. Mr. Butner, do you wish to contest or admit the violation?
Admit to it.
Admit to it? Okay, we'll go ahead and take that as an admission, and I'll go ahead and hear what the city has to say as far as this goes, and we'll figure out what to do, okay? So who's our code enforcement officer?
Angela,
Okay, you're still under oath, Ms. Yetter, so go ahead.
thank you. Sorry. As mentioned, this is case number C 2019-0237, respondent Charles and Nita Butner. Violation location 490 James Avenue. Real estate number is 323530.
And you do not need to go through your whole case anymore. He's admitting to the violation.
Okay.
So now you just need to ask for the relief that the city is
Okay.
requesting.
Wonderful. Do we need to admit evidence?
We do not need to admit evidence. We just need to give him a compliance date, and you need to
Perfect.
ask for a fine to be assessed.
Okay, so yes, what we would like to do is request that you find the respondent in his violation of the 6-52, but also to apply for and obtain permits for any and all work performed as to construction of the downstairs enclosure, or to obtain permits for removal of the unpermitted downstairs enclosure within 30 days of the date of the hearing, and to order the administrative fee of $300, as well as payment to the city of Marathon a fine in the amount of $100 per day for violations that continue to exist past the date of compliance.
And Mr. Butner, do you have anything you'd like to say, sir?
The only thing I was doing was putting a privacy wall down for my children to play downstairs. I mean, it's not for living or anything else. It's for my wife's gymnasium downstairs. That's worth about $30,000, and the wind and the rain was ruining it. We just put up plywood on the side, inside of it, not on the walls even. And
Okay. I'm having a little hard time hearing. It might be the mask. I apologize. But you said all you guys did was what? I'm sorry.
just trying to protect the downstairs from the rain, from the wind. There's nothing else downstairs but my kids' gymnasium. I have 4 kids and that's their playground. So it's, we're just trying to protect it from the weather. I mean, there's no construction of any kind of, you know, making of bedrooms or anything downstairs. There's no plumbing going on, just a plywood as a courtesy wall.
Okay, so, well, you made an admission to the violation. Are you saying that you want to contest the violation and say that you weren't doing construction?
Yeah, it's not construction, it's just a privacy wall.
Okay.
If
At that
if
point,
that's the case, Your Honor, then the cities will go ahead and put on their
yeah,
case.
yeah, that's what I was saying. What I'm going to do, Mr. Butner, just to be fair, I'll let you go ahead and take back your admission and you go ahead and enter a denial. Doesn't make a difference on the fine. If, you know, if you're found in violation, it's not going to be a higher fine because you denied or anything like that. So I'll go ahead and I'll go over to Ms. Yetner now and ask Ms. Yetner to go ahead and introduce the evidence. Okay.
Okay.
Okay, go ahead, Ms. Yetner. Ms. Yetter, I'm sorry, I'm putting an N in it. Maybe it's the Butner that's making me put an N in Yetner. I don't know. So go ahead.
So give me one sec.
So I'd like to introduce some evidence as far as our case.
Okay.
And the first page here is the property record card for Monroe County showing ownership and location of the property.
Mr. Butner, is there any reason why I shouldn't look at that?
No, sir.
Okay, it's admitted.
And next we have the City of Marathon Code section regarding permits required for alterations on structures within the city.
Okay, let me just look at that for a second, if you would. Mr. Butner, you don't have any objection to me looking at this, do you?
No, sir.
Okay, go ahead. It's admitted.
The next exhibit is the notice of violation of stop work that was issued in December of 2019, as well as the certified mail receipt and the proof of delivery for that violation.
Okay. Mr. Butner, any reason why I shouldn't look at that?
No, sir.
Okay, it's admitted.
And including the notice of hearing on the stop order that was issued on August 1st, as well as the certified mail receipt and the proof of delivery.
Okay, Mr. Butner. All right with that?
Yes, sir.
Any reason? Okay, any reason, any objection to me looking at that?
No, sir.
Okay, go ahead.
And then next I have some photos taken and entered into our case notes for this case.
Does somebody else have a? Okay, go ahead and talk photos one at a time.
This photo was taken December 16th of 2019. It's the front of the structure and you can see the plywood there. The next photo also taken December 16th of 2019, and this is from the right of way showing a different portion of the structure. This photo was taken December 16th of 2019. It's the stop work order posted on the structure. And also December 16th of 2019 is another photo of the straight stairs and the downstairs with the plywood. This photo was taken May 16th of 2020. It showed the plywood still present. And we have this photo taken June 6th, showed some of the plywood as well as a tarp covering a portion of the downstairs enclosure that was put on.
Okay.
June 6th as well, you can see the tarp from a different angle. This photo was taken September 9th, showing that the plywood remains on the downstairs enclosure.
Okay.
Another photo from September 9th. This one is not very good, but you can see it's a brown tarp that's on the structure covering part of the downstairs enclosure.
Okay.
And another photo from September 9th showing the front of the house. And then another photo, this was on September 9th as well. This was from the right of way showing a different corner of the home and the plywood. And the last photo, September 9th as well, showing plywood on the downstairs.
Okay. Mr. Butner, is there any reason why I should not consider those photographs?
No, sir.
Okay. All right. Anything else from the city?
Ms. Yetter, did you personally observe the plywood structure documented in those photographs?
In photographs subsequent to my employment with the city, yes.
I should ask, when were you first employed by the city?
February 26th of this year.
And Mr. Bridges, I just realized I was on mute. Were you able to hear me through
Yeah.
Angela's microphone?
I was. Thank you.
With that, I believe the city would rest.
Okay, Mr. Butner, I'm going to give you a chance to ask any questions of the city you'd like to ask right now. I'll go ahead and swear you in because you may go ahead and start testifying too if you want to. You raise your right hand, sir. Do you solemnly swear or affirm that any testimony you give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Okay, go ahead and you can ask questions to Ms. Yetter, and if you want to go ahead and tell me your side of it, go ahead.
No, I was just saying that we just put it up there due to the weather, wearing on the material downstairs for the kids. We do have a lot of gymnasts and gymnastic stuff downstairs that I didn't want to get ruined. So we put the plywood up so the wind and rain didn't ruin it. When I got the permit or the stop work, we stopped the work on it, and then I received the letter. I didn't know I had to take it down until I had to come forward.
Okay.
I wanted to see if there's any way I could get with the building department or somebody I can talk to see if I can keep it up, what I have to do to make it, legal.
Mm-hmm. Okay. Could I go back and see the exhibits? Could I see the building code exhibit and the notice of hearing on stop work order? The code section, yeah. All right, let me just take a look at that again.
And then for you.
Construct, enlarge, alter, repair.
Definitely altered.
Okay, it says that you have to have a permit to construct, enlarge, alter, repair, move, demolish, or change the occupancy. As far as, altering and repairing, those seem a little nebulous, aren't they? Maybe Mr. Jones, you can help me out with this a little bit. For instance, I understand if you put another room on something, that's clearly altering it. If you I don't know, put a frame around a window inside, that's also altering it, right? Or if you put
Yes, Your Honor, and many times permits are required for those sorts of alterations. I would say that there are exceptions to that listed in the city code that are, for instance, certain signs do not require a permit, but this is the type of a structure. It is an illegal downstairs enclosure by definition, and it was by definition the alteration of an existing structure. And it was not something that was covered by an exception to the permit requirement. So therefore, it is something that does need to be permitted. The plywood itself is not something that can stay. Code, to the extent some sort of downstairs enclosure was built, would require flood vents, which these plywood sheets do not have.
That's what I was wondering about. Yeah. So
and so to the extent Mr. Butner is interested in trying to work something out with the building department, I think one of the ideas that I had heard tossed around just before the hearing was the possibility that a lattice structure might be something that could be put into in lieu of the plywood. There are ways to make this happen, but what we would ask is for a 30-day period for Mr. Butner to get with the building department to either apply for a permit that is necessary to permit the existing structure, or more likely to take it down and to replace it with something that would be built in accordance with city code.
and I'm going to step out of my place a little bit, but if I'm correct, Mr. Jones, a lattice structure usually would work, and you can get with those thick plastic sheets like they have in restaurants, outdoor restaurants, to cover up to keep the rain out sometimes, can't you? That probably would be acceptable, I would think.
I'd have to defer to city
Yeah.
staff on that, but I believe that is something that might be acceptable.
It's
Again,
not
I would.
Yeah, it's not my place to write the ordinance or anything like that, but maybe I'm trying to, give Mr. Butner an idea of something that might work. Check with Mr. Lewis on that first. He's the expert on that, not me. Real quick, could I see the notice of hearing on the stop work order also, if you don't mind?
Of course.
That sounded awful.
That is the notice of violation. I believe there's a notice of hearing in here as well.
Yeah. Mhm.
I did come to a hearing, but there was nobody here. They had canceled it.
I showed up for court the other day and nobody was there. And so I asked the judge if next time if I don't show up, could I, have a, here it is. Okay, let's correct it. Okay, and can you go on down a little bit more if you can? Okay, that's what I want to make sure, because it says down here, the hearing will be held on the following violations. I just want to make sure it wasn't just a hearing on whether he could continue to work or not. So I want to make sure he had proper notice. Okay, Mr. Butner, was there anything else you wanted to add?
No, sir. Thank you.
Okay, I do think in this case, and I'm certainly not making a value judgment on it, I think there was a violation here, putting up that plywood. The problem is when you put up plywood or any kind of a wall on one of those downstairs structures, it can mess up where the water goes in the event of a flood. Now, I understand you were trying to exactly prevent the water from coming in during the rain and ruining your kids' equipment. I certainly understand that, but putting up plywood like that would make a violation. The good news is, we're going to give you the 30 days to comply with this. If you need to get an after the fact permit, then by all means do so, or a demolition permit, or by all means do so. Talk with Mr. Lewis about what that is. If it's all done within 30 days, or you've got the permits to get it done within 30 days, there's not going to be any fine whatsoever. I do have no choice but to assess the $300 administrative fee though. So that's what I'm going to go ahead and do. Was there anything else, Mr. City Attorney, that I left out?
No, but I believe there's some discussion going around of if Mr. Butner could just stick around for just a minute or two. I believe somebody's going to come out with a business card just so he can reach out to the city building department and try to go ahead and get this worked out.
Okay. All right. Thank you, everybody, and good luck to you, Mr. Butner.
Thank you so much.
Thank you.
And Mr. Bridges, we seem to have had a Mr. Segredo is on the Zoom call with us. He is here on 2020-118. I would ask if we could go ahead and call that out of order as well.
Absolutely. Let me find it real quick. 2020-118. Okay. We'll go ahead and call the case C 2020-0118. The respondent is Plain Fun Holidays, LLC. Sitting in code enforcement doesn't seem like plain fun, but Raul Segredo is the registered agent, and the violations alleged are a stop work order was posted on the property by the building inspector on June 4th, 2020 for work on entry steps without benefit of a permit, and that there was building going on without a permit. So Mr. Segredo, you're here for Plain Fun, and are you going to admit or deny the violation, sir?
I'll admit the violation.
You'll admit the violation? Okay. What I'll do is I'll go ahead and I'll hear from the city of what their recommendations are, and then I'll come back to you, okay? So go ahead. Is this Ms. Yetter again?
Yes, sir. It sure is.
All right.
And so in light of the violation of chapter 6-52 and the work through the stop work order, we'd like to request that the respondent pay the city of Marathon an administrative fee in the amount of $300 for this hearing within 30 days. We'd like to request that the respondent be ordered to apply for and obtain a building permit with a Florida licensed contractor for any and all work performed without the benefit of the permit within 30 days. And as well as to request that the respondent's vacation rental license PLR 2020-00096 be immediately suspended until such time that a permit for the unpermitted work has been issued, approved, and finalized by the City of Marathon Building Department, as well as to request that the respondent be ordered to pay the City of Marathon a fine in the amount of $500 for each day the violations remain uncorrected past the date set for compliance, or upon a finding that the respondent has advertised or rented the property as a vacation rental prior to the permit being issued, approved, and finalized by the City of Marathon Building Department.
Okay, well, I didn't see anything, maybe I misread it. I didn't see anything in there about vacation rentals or anything like that. This seems like this was just unpermitted work. Am I correct on that?
Your Honor, the city's position is that this is by definition an unsafe structure. We are just hoping not to endanger the guests that we do know occupy this property. We do not believe that a revocation or lengthy suspension of the vacation rental license is warranted, but we would like to stop further rentals of the property until the work has been brought into compliance. It is the city's position. The property as is currently an unsafe structure because we do know that there was some pretty extensive work performed without the benefit of a permit, and until such time as the city can verify that this work was performed in accordance with code, the city believes that the structure remains unsafe for occupancy.
Okay. Now, Mr. Segredo, I haven't talked to you yet, but I'll say from what Mr. Jones is saying, I can understand wanting to suspend the vacation rental license for this at this point. However, as far as going up and doing a fine for each day that it may have been rented before all of this happened, that seems like that's something that's not charged at this point. So I wouldn't want to go down
Your
that
Honor,
road.
the $500 a day was actually for any non-compliance. It would be if the permits have not been applied for beyond the 30-day period. I apologize if there was some
Okay, that I can understand. I've got a quick question. Why $500 a day in this case? Because normally we do $100. Is it particularly egregious?
I would have to defer to Ms. Yetter on answering that, and you are muted.
The City of Marathon code allows for increased or enhanced fines when there's work through a stop work order.
Mhm.
And
Was
that's what
the stop work order was violated. That's your allegation.
Yes, sir.
All right. Mr. Segredo, let me go ahead and swear you in. Do you solemnly swear or affirm any testimony you give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Okay. What would you like to say? Or if you'd like to ask the city questions, you're welcome to do so.
Well, is the city aware that I did apply for a permit and a permit was issued? And I've, 14 days after the 4th, when the stop order was issued, I hired a contractor, LD Homes, and they applied for a permit. I understand it was paid for and it's been issued. And is the city aware of that?
You're on mute, Ms. Yetter.
Sorry, sir. The permit was applied for and was paid for, but was never picked up, and the permit card was never signed and taken to the job site.
I've endeavored to do that as late as today, and the permit wasn't issued to the person that was on site, my caretaker. So I can pay for it, I can apply for it, but if you don't give it to me, I can't take it.
Okay,
Your
why
Honor,
was it
I
not
think-
picked? Mr. Segredo, why was it not picked up?
Why was it not picked up earlier than
Yeah.
today? We've made multiple attempts to pick it up. Unfortunately, with the COVID process, there's a protocol that needs to be followed. We were told to show up today at noon to pick it up, and it wasn't handed over to my caretaker.
Your Honor, to go ahead and keep this simple, it sounds like Mr. Segredo may be in agreement with most of what we're asking, just disputing the timing of the permit having been picked up. I can tell you this, I don't think the city would object to a provision in the order stating that the city shall not unreasonably withhold the permit. But I think the issue is that I don't believe there is a contractor who has signed on to this permit. Am I mistaken about that?
LD Homes, sir. That's a contractor that signed the permit application.
Okay.
And as far as the other matters having to do with the rental of the property, although I'm not renting the property currently, I believe that's overreach on the part of the city right now, because there's no evidence that I have rented it in this time that you're alleging the stop work order was in effect.
Okay. So it sounds like Mr. Segredo may very well be in compliance as soon as he picks up the permit, correct?
Your Honor, could
Yes,
you
sir.
swear me in for a minute?
I can. Mr. Lewis, do you solemnly swear or affirm the testimony you give be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Okay, go ahead, Mr. Lewis.
We have evidence that the contractor that applied for the permit withdrew, did not do any of the work, and does not want to be a part of this permit. So that's part of our position, is we do not have a contractor. We have a contractor that applied for a permit and withdrew. So the owner's going to need to come back in, apply for a permit with a licensed contractor, because of vacation rental, he cannot do a owner permit. But we would be happy to issue the permit. He's had months to pick this permit up, but this is not something like from today. This permit was getting old, and we've had evidence for a while that the contractor withdrew.
Mr. Segredo, do you want to ask Mr. Lewis any questions, or do you want to say anything?
Yeah, when did the contractor withdraw?
I don't have that in front of me, I'm sorry.
And did they send notice to the city or to, because I haven't received notice from the contractor that they withdrew. I paid them. I have evidence that I paid them.
Again, that would be between you and the contractor, but according to staff, we have a letter September 2nd
Could
that
you
the
put that into
contractor
the record,
withdrew.
please?
His reasoning was the work, he did not do the work, someone else did the work. He didn't want to be on the permit for other people's work.
Could you put that letter into the record, please?
I'm sorry.
Could you put that letter in?
And we can get you a
Yes.
copy of that.
I'm not really sure it's going to be relevant to this issue right here. Let me ask you this, Mr. Jones, the city was requesting a 30-day compliance date, is that right?
30-day compliance date, Your Honor. I think regardless of whether the existing permit is going to be sufficient or not, I think the parties seem to be in agreement that 30 days to get the permit, either because picking up the existing permit or applying for a new one with a new contractor. Either way, if a permit is applied for in the next 30 days, otherwise we would ask for, and this is, I think, how the order can read, Your Honor, $500 a day for non-compliance beyond the compliance period. We would also ask that the vacation rental license be suspended until such time as a permit has been applied for. Again, if we have an existing permit, then the suspension will be done as soon as it's imposed. However, the city does believe we may have some issues with the permit that has been applied for already. But again, we can also be providing Mr. Segredo some contact information for the city to make sure that we can try to work through these issues as best as possible. I certainly have also no objection to a provision of the order to address Mr. Segredo's concern. The city will not unreasonably withhold the granting of a permit if properly applied for.
I'm sorry, Mr. Jones, but the permit's been issued, it's been paid for, you just won't give it to me. So you're asking for something that's already been done.
Okay, let me explain what's going to happen, Mr. Segredo. First of all, you're not going to be fined anything today other than that $300 administrative fee. I don't have a choice but that. There's been admission. I have to give the $300 administrative fee. All right. I'm going to find, based on the admission, non-compliance, 30 days to apply for and pick up a permit. Now, I understand where you're going as far as this goes. I'm going to say the city shall not unreasonably withhold a permit. So I'm going to suspend the vacation rental license until the work is actually done, not just until the permit is pulled, but until the work is actually done. And so after that, if after 30 days, there is not a permit that's been pulled at this point, I'm going to assess a $250 a day fine after beginning 30 days from now, if the permit has not been pulled. You've got time after that to get the work done. You probably need to get a hold of LD Homes and have a conversation with them to find out what's going on with them. Of course, that's between you and LD Homes, especially if you paid them. If for some reason you feel, now let me tell you, as you've seen some of the other hearings that have come up today, we have what we call non-compliance hearings. Those are some of the ones that we had at the very beginning, where the city comes back after a while and says, look, they didn't comply. They were given a compliance date, they didn't comply. If the city brings a non-compliance hearing against you and your defense is that the city would not give you the permit like they're supposed to, then that would possibly get you out of non-compliance at that point. But I would really, really try as best as you can to get that permit, work with Mr. Lewis, pick up the permit, work with LD Homes, find out what's going on as far as that goes. You got 30 days to do that. And if you do that, there's not going to be a fine at all. All there is going to be is just the $300 administrative fee. Do you understand what I'm saying, sir?
Yeah, I do, Your Honor. I don't believe it's fair and equitable.
Okay.
I have worked hard and diligently to comply. I've paid contractors, I've paid their building permit fees, and because of folks that are beyond my control and didn't even give me notice, I now find myself paying a $300 fee for something that the city should have known, because the city sent me this notice on August 31st. How could you know if the contractor withdrew on September 2nd?
Well, that's something I think you need to talk about with your contractor.
Well, they would know. Why did the city send me a letter on August 31st for a contractor that withdrew on September 2nd?
Your Honor, because the permit had not been applied for and picked up at that time. We're still in the same exact position today as we were on August 31st. The only difference is that now we've been notified that the building permit that had been applied for, which Mr. Segredo admitted he did not even attempt to pick up until today. Now we have a contractor who in the interim has reached out to the city and informed us that the permit that has been applied for is not going to be valid anymore because they are no longer willing to have their name associated with it. So again, whether it be this permit, the one that is already in place and that may be able to just simply be picked up if we can clear this all up, the issue with LD Homes, it may be as simple as that. Otherwise, a new permit with a new contractor will need to be applied for. And I think the order is pretty clear about what needs to happen.
All right, so that's
I
what we're going to. Go ahead, Mr.
wanted to challenge one thing here. Galen Jones spoke on my behalf that this was the only attempt to pick up that permit, and it was not. There's been several attempts to pick up the permit.
I recall you saying that. I do. And so, all right. So, and again, I'm not finding that you didn't pay LD Homes or anything. I'm not finding that they're right and you're wrong. You know, all I know is that it just hasn't been picked up at this point. Maybe you've got a conversation that needs to be held with LD Homes that probably won't be just plain fun either. But talk with them and see what's going on. And if they're really withdrawing from it, then you might want to look at getting your money back and getting somebody else to pull that permit. Again, you got 30 days to do it. If you do that, there's not going to be a fine. Okay.
Okay.
Thank you very much. And y'all have a good day. All right. Good luck to you. All right. Mr. Jones, any other cases you want to call out of order? You're mute.
Sorry, Your Honor, there is actually only one case left, and I don't believe there is anybody here for the respondent on that one.
Okay.
Unless somebody has entered City Hall in the interim.
Okay. Is this Edmund James?
This is 18-440 Mariners Place Land Corporation.
18.
Edmund James
okay.
has been withdrawn, is that correct?
Okay, that's been withdrawn. Okay, so we'll call case C 2018-0440. Respondent is Mariners Place Land Corporation. Carlos G. Burdillo is the registered agent. The violations alleged are stucco and drywall work performed without the benefit of a permit. Subsequently, permit number such and such was applied for, which would cover the work performed. However, it is insufficient, and to date, no additional documents have been submitted to the city. This is violating the code section 6-52A1B. We all know what that is. Building or site preparation, permits required, and the exceptions thereto. So if the city, so again, I'll go ahead and call out. Is there anybody here from Mariners Place Land Corporation? Mariners Place Land Corporation. Okay, nobody has heard. And who is our code enforcement officer? Is it Ms. Yetter?
I'll give you 3 guesses, Your Honor.
All right, go ahead, Ms. Yetter. You're still under oath. And you are muted too.
Up on screen.
Sorry.
That's all right.
How much detail would you like me to go into?
You're going to need to present your case.
Oh, okay.
Prove the case. Yep.
All right, so we have C 2018-0440 Mariners Place Land Corporation, registered agent Carlos Burdillo. Violation location is 20 Cocoa Plum Drive. Real estate number is 362840. And I'd like to introduce some evidence into the record, please.
Go ahead.
The first page is the property record card reflecting ownership and location. The next page we have is the Sunbiz registration for Mariners Place Land Corporation, the owner, as well as the identification of the registered agent that we've noticed on this case, Carlos Burdillo. We have the City of Marathon Code Section 6-52 requiring permits for work on structures.
Okay.
And we have the notice of violation, as well as the certificate of service and the proof of delivery.
Come in.
We also have the notice of hearing
Mhm.
which is also followed by the certificate of service. And we did not have good service on the notice of hearing, so the property was physically posted on September 4th.
Last case. Mhm.
I've attached a copy of the posting notice as well as the affidavit of posting. And finally, we have photos going back to December 5th of 2018 of the property showing our investigation into the status. So this is the front wall taken December 5th of 2018. And also December 5th of 2018, you can see active construction and repair in progress. December 5th of 2018, this photo was taken showing part of the structure. And we have a photo from December 5th of 2018 showing materials and scaffolding.
Mhm.
December 5th of 2018 showing some work area and some materials covered. And photo taken December 5th of 2018 showing another facet of the structure's front.
They did a nice job.
Yes,
All right.
yeah. And next photo is December 15th of 2018, the stop work order that was posted on the property.
Okay.
And then just a wider angle view of that December 5th, 2018 posting. The following image is from June 11th of 2020, showing some front face of the structure.
Mhm.
The following photo is taken July 9th, and it was actually in the notice of posting for the July hearing, which we did not have. But immediately following that is September 4th of 2020 photo showing the posting notice for this hearing.
Okay. And once again, I'll call out, is there anybody here for Mariners Place to object to these admissions? The exhibits will be admitted.
And Your Honor, before Ms.
Ms.
Yetter
Yetter testifies, I would like to call City Staff Cody Ward.
Mr. Ward, would you raise your right hand, please? Do you solemnly swear or affirm that any testimony you give be the truth, the whole truth, nothing but the truth, so help you God?
I swear.
Thank you, sir.
Mr. Ward, I'm going to bring up some photographs on screen that were just introduced into evidence as city's exhibit. You recognize this photograph right here?
I do.
Do you know who took this photograph?
I believe it was me.
And does this photograph appear to be a true and accurate representation of the photograph that you took on December 5th, 2018?
It is.
With that, I have no, and would you say that the photographs that we just took a look at moments ago are all true and accurate copies of the photographs that you took?
Yes.
Thank you. And I have no further questions for Mr. Ward.
Okay.
I would turn things back over to Ms. Yetter.
Ms. Yetter?
Okay, thank you. So as we've mentioned, the violation that we allege has occurred is to Chapter 6, Section 6-52. There was communication with the owner in this case, advising that permits needed to be corrected. And in fact, 2 extensions for compliance were granted within the code department. And in April of 2020, the contractor was contacted regarding a status without response. On May 7th, the owner was contacted for status without a response. And on July 9th, in direct response to the notice of hearing for the later canceled July 16th code compliance hearing, the owner did call in and I discussed with her, with their representative that despite a dispute that they had with their contractor, they as the property owner remained responsible for proper permitting and for the work that was done and that needed to be done on this structure.
So they've been told 3 times about these permits that they haven't gotten yet?
I would say that is more than 3 times because that is just what's documented in our code compliance chart case, in addition to the building department's communications with them.
Okay. Anything further from the city?
Would you like me to
just ask for the relief.
Okay. I would just request, Your Honor, that you find the respondent in violation of Chapter 6-52 of the code, order that permits for any and all work performed or necessary be applied for and obtained within 30 days from the date of today's hearing, and that the respondent pay an administrative fee of $300 for today's hearing. And that for any date beyond the date set for compliance, that these violations continue to exist, that a fine of $100 per day be levied, please.
Okay. One last time, is there anybody from Mariners Place present? Nobody here from Mariners Place. Based on the evidence, I'm going to find there is a violation. The owners are required to apply for any and all permits up to and including after the fact permits within 30 days of today's hearing or the rendition of the written order. There's a $300 administrative fee assessed, and a fine of $100 a day will begin to accrue against the property for each day after the 30 days, the day of compliance. Anything else?
With that, Your Honor, I believe the city has no more business for you today.
Okay, that's good. I have no more business for the city today, so everything is good. Thank you all. It's good to see you all. Thank you for everything. And whoever set up the technology, again, I appreciate that. You've made it a lot easier.
Galen did all the work on that.
No, Mr. Lewis is now the city Zoom expert.
I do have one question. Where did that paint come from on the wall behind you?
Everybody asked that question. I even have the chair I'm sitting in is green, and I even have a bowl of green apples that I always keep in my
Oh,
office.
nice. I've never been in your office, so I had no idea.
That's right. Okay.
I just have to ask,
Mr. Bridges, you had to buy yourself a gaming chair?
Yeah, that's my actual chair that I sit in is a gaming chair, and I have a little round table with little green chairs next to it. All right. Thank you, everybody. Y'all have a good day.
Thank
Great
you.
one.
Bye-bye.